Minister.
Thank you, Mr. Deputy Speaker. Well, it's a pleasure to rise and move the second reading of this bill. As members have said this afternoon, at the very heart of this bill is a desire to protect the public, our first duty as members of Parliament and our first duty as a government. There is no duty more important than protecting our fellow citizens. So it's right as we do this that we remember and pay tribute to the members of the emergency services who have put themselves in harm's way defending the public, and in particular, of course, PC Keith Palmer, who gave his life just a few yards from where we now stand. And we remember and pay tribute to those people who have so sadly and tragically lost their lives to terrorism of many different kinds over the past few years. And as I look across the chamber, of course, I see Joe Cox's shield up there, one of our own members who was so brutally and savagely and disgustingly murdered back a few years ago. And I think in the spirit of this duty of public protection that binds us all together, the spirit in which this debate has been conducted is a very heartening one. Of course, as the Honourable Member for St Helens North mentioned, there will be points that we will debate, I'm sure, forensically at committee in the coming weeks. But the broad principles we're debating today are ones which command cross-party support, and I think are an example of this House at its very best. And for those people who think British politics is broken, listening to this debate this afternoon, I think, proves them categorically wrong. I must say the speech given by the Shadow Secretary of State, the Right Honourable Member for Tottenham, was statesmanlike in its quality, and I greatly enjoyed listening to it and indeed learnt from it. I think the speeches we've heard from members of the House, the Select Committee chairs, the Home Affairs Select Committee Chair and the Justice Select Committee Chair, from long-standing and experienced members such as the Right Honourable Member for South Holland and the Deepings, gave all of us great pause for thought, and of course the speech by the SNP frontbench spokesperson, the learned member for Edinburgh South West. But as my opposite number said in his remarks a few moments ago, I was struck by the enthusiasm and the force and the thoughtfulness from members of the 2019 intake, all of whom made a tremendous contribution and, more importantly, will continue to do so in the years ahead. The House is richer for their presence here. And, of course, I must welcome to his place the Honourable Member for St Helens North. I'm delighted to see him on the front bench. We worked together on Helen's Law. Without his work, that would never be on the statute books. And I know that Marie McCourt and many victims are grateful to him for that work, which will now continue from his deserved and rightful place at the dispatch box. Now, Mr Deputy Speaker, I should probably turn to some of the specific points that have arisen in the course of today's or this afternoon's debate. And I'll start with TPIMs, which I think were the most extensively debated of these measures. I would like to thank the Honourable Member for Normanton, Pontefract and Castleford for the consistency with which she has advocated on this point, although I note that consistency from 2005 doesn't quite extend to the burden of proof, but it seems to extend to most other elements. And let me start with that burden of proof question. Why is it, many members have asked, are we returning to that burden of proof, that reasonable grounds for suspicion that was contained in the original 2005 legislation moved by the then Labour government? And it is a delicate question, as members have said. But as we consider the burden of proof that's appropriate, we of course have to balance and weigh the rights of the subject, whose liberty is being to some extent curtailed, with our duties to protect the public. We've spoken this afternoon about the victims of these terrible terrorist offences, and I think we in public office, members of Parliament, in the government, have a duty to think very carefully about our duties to protect people who might become victims of these terrible offences. And in answer to the question, why are we proposing the burden of proof where we are? It's because it gives the government the maximum reasonable ability to introduce TPIMs where they are necessary to protect the public. And by setting the burden where we suggest it, a reasonable suspicion rather than a reasonable belief or on the balance of probabilities, it gives the government, it gives the Home Secretary, the ability to act more widely than would otherwise be the case when critical public safety is at stake. I will, of course, give way.
So, can the Minister tell us how many cases in the last 2 years have not met the current threshold but would have met his lower threshold?
Well, as the Lord Chancellor said, we're not going to comment on individual cases. And, of course, as the Honourable Lady knows, the number of TPIMs in force are very, very low. It's only 5 currently. And we're not talking just about what may have happened historically. We are looking prospectively into the future at what measures we may need to take in due course to protect our fellow citizens. Now, in the question of... if I may just develop this point, then I'll give way. Now, in relation to the question of safeguards, members have asked, what are the safeguards? Now, the first safeguard is that the Home Secretary, who I can see is now in the chamber, does not, who of course is a doughty defender of public safety and public protection, does not act without fetter, because when a TPIM order is made by the Home Secretary, it is reviewed by the High Court under Section 6 of the 2011 Act, and the High Court has to give permission before that TPIM can come into force. And if the High Court find it is, and I quote the Act, obviously flawed, permission is not granted. So there is a judicial safeguard inherent in the structure of TPIMs. And if the subject of the TPIM feels they have been unfairly treated or unfairly dealt with, they may go to the court for a judicial review. So there are significant safeguards inherent in the structure of TPIMs. And as I said a moment ago, the government uses these extremely sparingly. Our preference, of course, is prosecution, as it rightly should be. We only use TPIMs where absolutely necessary to protect the public, and we make no apology for doing so. Only 5 are in force at the moment. I think that's evidence of how carefully the government applies these measures. And since 2011, despite the mechanisms, the judicial mechanisms I've just described, not a single TPIM has been overturned. So I hope that gives members confidence that there are safeguards and these are being used in a thoughtful way. Now, we've heard reference made to the opinion of the independent reviewer of terrorist legislation. Now, of course, we listen very carefully to what Jonathan Hall QC has to say. We study his advice very carefully. We very often follow his advice. But it is for this House and for us as members of Parliament to reach our own decision, which may, in many cases, accord with the independent reviewer, but in some cases it may not. And where our judgment differs, we should exercise our independent judgment, as we are doing in this case.
Will you allow me now?
I will, of course.
I think in his references to TPIMs, he may have answered a question that I was hoping to ask him a little later on, and that is, what do we do about that category of people who have gone abroad to fight for terrorist-backing organisations and return to this country where there is not enough evidence to prosecute? And I think that the bill doesn't say a lot about this. If I'm wrong, will he correct me? If I'm right, surely this is an area where TPIMs might be relevant.
Indeed. Well, look, in relation to people who go overseas to assist terrorist organisations, where we can, of course, we deprive them of their citizenship, if it is lawful, if they are, for example, dual nationals, to prevent their return here in the first place, and it is right that we do that. Secondly, on their return, it is our preference, if there is our strong preference, if there is sufficient evidence, to prosecute them under the criminal law, as we very often do. But if there are evidential difficulties and we cannot meet the burden of proof required by a criminal court beyond reasonable doubt, but if we do have a reasonable suspicion, if the bill is passed in this form, then we can use TPIMs to protect the public. And that is an excellent example, if I may say, from my honourable friend, the member from the New Forest, illustrating exactly why these TPIMs could help us. In those cases where we can't achieve prosecution, evidence from, say, Syria, it's very hard to gather, but we do have a reasonable suspicion. And it's in those cases we must act to protect the public. It's very briefly.
press this point again. The Minister has still not given us any reason why the current system is no good and why it doesn't work. He said independent judgment, but he's giving us no evidence on which to make our independent judgment that's different from the reviewer.
Well, I think, I must say, we're returning to a situation that was enshrined originally in 2005, which honourable members opposite strongly supported at the time. I've made the case already that it gives the Home Secretary an ability to take a rounder judgment if the proof threshold is set at reasonable suspicion rather than reasonable belief or balance of probabilities. And I've made the case that we need to just be very mindful of protecting potential victims. And we need to think about this not just retrospectively, a sort of historic review of case studies, but prospectively, how we may need this power in the future. I've explained the safeguards in place, and I've proved that the government uses these powers very sparingly. So I think, Mr Deputy Speaker, if I may say, I think I have made the case for the legislation as it is currently drafted. Mr Deputy Speaker, let me turn now to the question of de-radicalisation and reducing reoffending. The Right Honourable Member for Tottenham, the Shadow Lord Chancellor, very powerfully referred to this in his speech. And let me be clear, we are not giving up hope on any people who are convicted of terrorist offenders, especially young people, but frankly, we're not giving up hope on anyone. Although these cases are very hard and rehabilitation is very difficult, we will never give up hope. And there are cases, such as Majid Nawaz, the founder of the Quillam Foundation, who did harbour extremist ideologies, but have now fully reformed and in fact are now powerful and moving advocates for tolerance and moderation. And I look to examples like that for hope, and it gives me hope. And it's in that spirit that the government have been investing in this area. I think it is fair to say there is more we need to do in this area to meet our aspirations. But in January, we announced an additional £90 million for counter-terrorism policing. We have doubled the number of counter-terrorism probation staff serving, and we've introduced new national standards for monitoring terrorist offenders on licence, which includes work with psychologists to try and address any mental health issues that may relate to this sort of offending, and also actually involving imams to try and explain that in the case of Islamist offending, that Islam is a peaceful religion, and the interpretation that some of these offenders have is a perversion of the true meaning of that great and peaceful religion. So we are involving them in our work. And things like the Theological and Ideological Intervention Programme, the Healthy Identities Programme, and the Desistance and Disengagement Programmes are all designed to do the same thing. I don't pretend that those systems are working as fully effectively as we would like. I acknowledge there is more work to do, but that work is happening. It is being invested in. And as I said a moment ago, I do have hope that people can be turned onto a different path, and that ultimately must be our objective. Mr Deputy Speaker, let me turn now to the question of the removal of the Parole Board's function in relation to people who will now serve their full custodial term in prison, those most serious offenders. It is right that we do that for the reasons that have been laid out. For these most dangerous offenders, they should serve their full prison sentence. I think the public expects it. We've acknowledged the fact that there needs to be rehabilitation taking place subsequently in the extended licence period, provided after their release. And although there'll be no parole board intervention, as the Shadow Secretary of State pointed out in his speech at the beginning, there is plenty of other intervention that will take place. For example, very extensive MAPA work will take place throughout the custodial sentence. The prison service and prison governors, excellent governors like the governor at Belmarsh, will do enormous amounts of work with the prisoners during the course of their custodial sentence. And of course the probation service, in the way that I've just described a moment ago, will work with the offender on their extended licence period afterwards. So although the parole board won't be making the release decision, that has effectively been made by the judge at the point of sentence in handing down a sentence of this nature. A huge amount of work will nonetheless be done to manage, to help, to monitor, and where appropriate to intervene during the prison sentence and during the licence period subsequently. So I am satisfied, the Lord Chancellor is satisfied, that these arrangements are comprehensive and will be effective. Mr Deputy Speaker, let me say a word about polygraphs. The member for Edinburgh South West referred to these, and I think the member for Belfast East did as well. It's very important to stress that the use of polygraphs we're proposing here is the same as the use currently deployed in relation to sex offenders on licence. Now, these polygraph results, because they're not entirely accurate, they're quite accurate, but they're not entirely accurate, they don't create any binding consequence. If somebody fails one of these polygraph tests, what happens on licence? What happens is further investigatory work is done by the police or the probation service. It triggers further work, which will then produce a conclusion one way or the other. So they don't produce a binding result, but it serves as a trigger. And if we look at the way they've been used in relation to sex offences, we find that the level of disclosure of relevant information by those sex offenders to whom polygraph tests are applied has increased after the introduction of these polygraph tests from a 51% disclosure rate up to 76%. So they have been helpful. They're not a panacea, they don't tell you everything, and you cannot wholly rely upon them. But they do yield some information, as a result of which further investigation can be conducted. Mr Deputy Speaker, some questions were asked about the Prevent Review. We are very close to appointing a new chairman of that review, which is overdue, as members have quite rightly said. In terms of our revised timing, members asked, again quite rightly and quite fairly, what our revised target date is for that review to report. And our target date is August 2021. That is a year later than originally anticipated, but members will understand that with the resignation of the initially appointed chairman and then the coronavirus outbreak, it has unfortunately caused that 1 year delay. But that is the timetable we are now working to. Finally, Mr Deputy Speaker, the member for Belfast East and his colleague from North Down made reference to the application now of the ending of the automatic early release of terrorist offenders to Northern Ireland, and I'm delighted that the member for Belfast East welcomes that application. We had thought very carefully about the legal implications because the structure of sentences in Northern Ireland differs to that in the rest of the United Kingdom. That's why we didn't act in February. We've now thought about it very carefully. We've taken very extensive legal advice, and we are now wholly satisfied it can properly be applied to Northern Ireland without any Article 7 or indeed common law retrospectivity infringement, and that is why we now include Northern Ireland in these provisions, and of course, as you know, because we want the United Kingdom in these terrorist-related matters to act as one, it is proper that we do so. Mr Deputy Speaker, terrorists seek to divide our country, they seek to divide our community, they seek to create hatred against one another. But I think in the conduct of our debate this afternoon, we have demonstrated that no matter what our differences may be in day-to-day political matters, we will stand as a House of Commons and as leaders of our various communities together in solidarity, in unity, against all of those from all different wings of the terrorist fraternity. We will unite against hate, and we will keep in mind Jo Cox's words in her maiden speech, which I remember listening to 5 years ago from the backbenches. She said, "There is more than unites us than divides us." Let us keep those words in mind, and let us fight terrorism of all kinds wherever we find it. Yeah.